It's time for you guys to start being journalists.
Before an angry Andrew Baldwin left the courthouse, 13 News overheard him speaking to Richard Allen's wife, saying, "It ain't over. The world's watching. The world sees what's going on."
Hello, good morning, good afternoon, good evening. I hope you're all doing well. We're here to do part 2. I did say last night that I would be back same time tonight, and here I am a little bit later than I was last night because I gave people a chance to watch Cold Case Christmas. Episode 19 came out over on Michelle Walks just half an hour ago. So if you've watched it, I hope you enjoyed it. If you haven't, then the case is an Irish case, and it's Connor and Sheila Dwyer who mysteriously disappeared. It's all very odd. It's an odd one. So, here to talk Delphi and Richard Allen's appeal. So, I know there's a lot of people been talking about this, a lot of people going through the appeal brief. I decided to split it up into 2, like part 1 and part 2, basically because I like to digest things. I like to go away and think about things. And this was a good place to stop last night. So yesterday we did the first half, which is just a factual basis of the appeal. And what we're going to do now is look at the legal basis for the appeal. So it's kind of the same thing, except there's the law in, like, all the laws in there as well. So that's where we're going to start. So hello, everybody. I'm not going to say individual hellos. I'm just going to go, hello, everybody. I'm going to get straight into this. I did read a little bit more of this last night when I got off the live stream, but I didn't get to the end of it. So there are some things that are going to be completely new to me. And I have watched a couple of live streams. I think I watched Defense Diaries and Criminality, and ended up falling asleep before the end of both of them. So I don't know what's wrong with me at the moment. I just keep falling asleep. I would say it's quite unlike me, but it really isn't. It really isn't. I can fall asleep on a clothesline. So I have genuinely not seen the end of this document. I haven't had it read to me, and I haven't read it myself. So let's just get into it, shall we? Okay, so we're starting on page 59 for those who are counting. So this is the argument. Number 1, the trial court committed reversible error by admitting evidence seized from the unconstitutional search of Allen's home and denying a Franks hearing. When reviewing the admission of evidence after denial of a motion to suppress, the court considers evidence favourable to the ruling and uncontradicted evidence to the contrary. Now, I'm not going to read all of the citations, and I certainly haven't gone through the citations. So if somebody wants to go through every single citation and make sure that they're spot on, then have at it. Factual findings are reviewed for clear error, but the constitutionality of a search is reviewed de novo. Allen filed a motion to suppress, a motion for Franks hearing, amended requests, and a lengthy memorandum with exhibits. We know it was lengthy. Franks 1 was 136 pages, I think it was. And then there was Franks 2, Franks 3, and Franks 4, which were all in addition to Franks 1. I don't believe that Frangel read any of them. I truly don't believe that she read any of them. I just don't. She could prove me wrong, but I don't think she did. The trial court denied the motion and hearing concluding Liggett's affidavit did not include false statements or omit facts with reckless disregard to intend or mislead. Okay. The trial court erred by concluding Detective Liggett did not make false statements or reckless omissions in his affidavit. Both the state and US Constitution guarantee that no warrant shall be issued but upon probable cause supported by oath or affirmation. The state must include all material facts in a warrant application, including facts that cast doubt on the existence of probable cause and sources' reliability. A warrant is invalid if 1. The police omit facts with the intent to make the affidavit misleading or with reckless disregard for whether it would be misleading. So I think we can give a tick to that. It certainly was misleading. 2. The affidavit supplemented with the omitted information would have been insufficient to support a finding of probable cause. The defendant must prove a reckless or deliberate false statement by preponderance. An officer omits evidence with reckless disregard if the officer withholds a fact in his ken, interesting, that any reasonable person would have known that the judge would wish to know. So would you, as a reasonable person, want the judge to know that certain facts were exculpatory? A reasonable person might want that, but not Tony Liggett. No, certainly not Nick McClelland, who sat through this case, and how that man sleeps at night, I've got no idea. This includes details undermining an officer's conclusion. Okay, that's just some details about those cases. So Detective Liggett omitted and changed key information that undermined his conclusion that Alan was bridge guy. Liggett misled the court in 4 ways. First, Detective Liggett misled the court to believe Blair's description of the man on the bridge matched Alan when it did not. No, it was a young man with poofy hair. Liggett told the court that Blair said the man was standing on platform wearing blue jacket and jeans. But Liggett omitted the rest of Blair's description that did not match Alan. The man had brown poofy hair, like the sketch below, was in his 20s or early 30s, youthful and medium build. None of that describes Richard Allen. Second, Liggett misled the court that Allen's car was parked at the old CPS lot during the time of the kidnappings. Detective Liggett told the court that after Blair saw the man on the bridge, she saw 2 girls she thought were Abby and Libby on the trail approaching the bridge. As Blair was leaving the trail, she saw a car oddly parked at the CPS lot. Around 2:10, another witness, Wilson, also saw a car backed into the CPS lot, as if concealing the license plate. Both witnesses drew diagrams of the car parked in the same general area and manner. So the chances are they both saw the same car, you would think. Okay. Liggett told the court that Allen parked his black 2016 Ford Focus at the old CPS building, but admitted that Blair said the car she saw during the time frame of the kidnapping was not black and had sharp angles like the sketch below. So black, not black, curvy, sharp. Great sketch, but I think she's trying to get across that these were sharp angles, not like this curved hatchback here that you see in the Ford Focus. No. But definitely not black. I think the bigger thing is that she said it wasn't black because black stands out, doesn't it? Black, or if it was really dark blue, or really dark, a really dark color, really dark green, even just seeing it at a glance. But saying that it definitely wasn't black is interesting to me. Interesting. So it excludes Allen's black hatchback. This is a material omission. Third, Liggett misled the court that the man walking on 300 North was Bridge Guy. Liggett falsely told the court that Carbo in 2017 claimed the man was muddy and bloody wearing a blue jacket, when she actually said his jacket was tan and he was muddy. I think someone going home. I don't think that's anything to do with the case at all. I think if she did see someone, she certainly didn't see them for 30 seconds as she drove by at 30 miles an hour. But if she did catch a glimpse of someone and they were muddy, I think it's probably someone's walking home from their job. It's probably like farms and stuff around there. A bloody man in a blue jacket matches bridge guy. How would you know? Like, just going by. Like, you're not looking at somebody for 30 seconds if you're driving at 30 miles an hour. How would you even know that that person was bloody? And if you thought that that person was bloody, why wouldn't you stop and ask them if they need assistance? You know, do you want me to call 911? Are you injured? You know, if you got blood all over you, you don't automatically go to, oh, that person's just committed a double homicide. You go to, that person's injured. But no, because he wasn't bloody. Liggett also admitted that Blair told him the man she saw on the bridge was not the same person Carbo described. ISP even released a public statement that the men were not the same person. Fourth, Liggett connected Alan to Bridge Guy by falsely claiming Alan admitted wearing a black or blue Carhartt and a head covering. The man the four girls saw wore the same clothes as the man on Libby's phone. And honestly, the girls gave different descriptions of the man. And I don't know that it's in here. But one of the girls said that he was taller than her, and she's 5'7", and he was taller than her. So Richard Allen, the first thing you'd notice about Richard Allen as a man is his height. Now, they've got Allen at 5'6", but in the prison records, he's either recorded as 5'4" or 5'5". So he's smaller than 5'7". So a 5'7" person would look at the man coming towards him and think he's small for a guy. That's the first descriptor that you would give. But no, the girl that gave an assessment of height said he was taller than her. So not Richard Allen, not him. None of them saw Richard Allen. None of them did. Dear God. And probably 3/4 of the guys who were out on the trails that day wore jeans. And the majority of jeans are blue. So come on now. Alan told investigators he did not know what he was wearing. Although Liggett used Alan's wife's statement that Alan currently owned a blue Carhartt as a nexus to his home, nexus, great word, Liggett admitted that she said he purchased his coat a couple of years ago. The girls were killed in 2017, so he would have bought his coat, 2020? They need to find that receipt for that coat. Had the court known Alan simply admitted owning a blue or black coat, I've just bought a new coat. Guess what colour it is? It's black. And it's a bit longer than Bridge Guy's. But from a distance, you probably could say that it's a similar coat to Bridge Guy's. It's a bit longer. But anyway, moving on. Had the court known Alan simply admitted owning a blue or black coat, as does probably every 50-year-old man, he would have known that there's no connection between him and Bridge Guy. Through Detective Liggett's omissions and false statements recklessly misled the judge. Any reasonable person would have known the judge would wish to know that Blair's description of Bridge Guy and the car at CPS did not match Alan or his car. In 2017, Carbo described the man walking down the road as only muddy, wearing a tan coat, not a blue jacket like Bridge Guy, and not wearing blood on him. Blair did not believe she saw the same man that Carbo saw. Alan never said he wore a blue Carhartt or head covering like Bridge Guy. He bought his blue Carhartt a couple of years before 2022. The omitted and false information strikes at the heart of Liggett's conclusion that Alan was the man on Libby's phone. The state's probable cause relies on a tight timeline, making Alan the man the 4 girls saw on the trail, Blair saw on the bridge, and Carbo saw on the road. Any judge would want to know if witnesses describe someone other than Alan, his car, or bridge guy. Moreover, the fact Liggett lied twice in the affidavit about the connection between Alan and bridge guy, i.e. the blue jacket, shows more than reckless disregard for the truth. These falsehoods were directed at connecting Alan and Libby's video, which would otherwise include any white male. Probable cause, right, number 3, with the omitted and accurate evidence, the affidavit was insufficient to establish probable cause. Yeah, don't go helping police with any inquiries. I definitely won't, no. Not with a black coat on, good Lord. Definitely not with some kind of nondescript black coat that probably, you know, it was cheap on Amazon. All right, it was on sale on Amazon. And I needed a new raincoat. So I got it while it was on sale. And probably loads of people have got the same coat now. I better definitely not help the police with their inquiries. Okay, probable cause exists when there is sufficient evidence to cause a reasonably prudent person to believe a search will uncover evidence of a crime. A reasonably prudent person would not believe Alan was connected to the murders or that evidence would be found in his home. The state is left with Dullard's report claiming Alan told him he was on the trails between 1:30 and 3:30. And that is just a claim, because Richard Allen in 2022 said he was there between like 12:30 and 1:30, 1:45. So we've no proof that Richard Allen said those times in 2017 because Dan Dullard never recorded the interview that he had with him. So we've only got Dullard's word that Alan even said 1:30 to 3:30 and saw 3 girls, not 4 girls, like those who thought they saw Bridge Guy. During his October 13th, 2022 interview, Alan admitted wearing blue jeans and owning a gun, knives, and a blue or black jacket, and walking out to the first platform of the bridge to watch fish. Now, numerous other people walked on that bridge that day. It was a very popular walking spot. Oh, and also it was unseasonably warm for a February in Indiana. There was loads of people out on the trails that day, some of whom would have walked out at least to the first platform of the bridge. It was something people did. And I'm sure loads of people own guns and knives in Indiana. But Alan does not look anything like the person Blair saw on the bridge. Also, his car is a different colour and shape than the oddly parked car. And the man Kerbo saw walking was most likely not even Bridge Guy. If Alan being on the trail within the same 2 hours the girls were abducted is enough for a warrant, law enforcement would have obtained one for Alan's home in 2017. And for everybody else who was on the trails that day. If that was all that was needed, well, we need a warrant for Betsy Blair's house. We need a warrant for the girls, those girls' houses that were there. We need warrants for the other people that were there. Wasn't there a couple there or something? Maybe a bit later, like arguing or something. There was a bunch of people out there. So let's search everybody's house. If that's all that's needed for probable cause for a search warrant, you got to search everybody's house. Stupid. In 2022, ISP had no more evidence connecting Alan to the murders than they had days after the murders, when Alan, like others, responded to their request for help. It was not enough then, and it was not enough in 2022, and it's still not enough. The error requires reversal. A court must suppress fruits of an illegal search. The state's entire case is built on Liggett's half-truths and falsehoods. Without the gun seized in the search, there is no opinion from Oberg upon which the state arrested Allen. And without the arrest, there are no confessions. If the warrant was illegal, the state has no case. He needs to be released. This is enough, in my opinion, to just release the guy. There's no case against him at all. And the jury had no right to convict him based on the lies and the falsehoods that the prosecution used in the trial. Even if this court finds the confession was not a product of solidarity, solitary, not solidarity. I thought that was wrong. I thought that sounded wrong. Solitary. Allen is still entitled to a new trial. Before a constitutional error can be held harmless, the court must find it was harmless beyond a reasonable doubt. Without the fruits of the search, the gun, a casing in a hot box, the Carhartt, knives, and a computer that they didn't find anything on. They didn't find anything on his devices that linked him to Abby and Libby or the crimes in any way. The state cannot prove the jury would have convicted. At minimum, Allen is entitled to remand for a Franks hearing. Even if Allen's exhibits to the Franks motion did not prove by a preponderance that Liggett deliberately or recklessly falsified or omitted material information, they entitled him to a hearing. A defendant who makes a substantial preliminary showing that an affidavit included a false statement or reckless omission necessary for probable cause is constitutionally entitled to challenge the warrant at a hearing. Denied without hearing, said Francis. To meet this showing, the defendant need not present conclusive proof, but must support their accusations with evidence and citations to the warrant application. Here, the court's denial of a hearing was legally erroneous because Allen made a substantial showing. Allen supported his claims with depositions, police interviews, and reports. Citing Liggett's application, Allen made specific arguments. In a final motion, Allen reiterated these points, urging the court to compare the affidavit with Blair's and Carbo's interviews. Tellingly, the trial court was willing to schedule a Franks hearing when Allen was represented by Fort Wayne attorneys, little dig at Francis here, but refused when the original attorneys were reinstated. Allen's constitutional protections are not contingent on who his attorneys are. Absolutely. Absolutely. The trial court erred by admitting statements Allen made while gravely disabled during his unprecedented pre-trial solitary confinement in a maximum security prison. As I said yesterday, and as I said in my my video on this morning, I did a Delphi video on this channel this morning. For anybody who hasn't seen it, I talked about the confessions there, and I think they are the strongest argument. I mean, they're all strong arguments, but those confessions, it's just absolutely diabolical. The way that he was treated in Westville is just disgusting and barbaric. And the fact that the confessions that he made while he was psychotic were used at his trial, or even shown to the jury at all. But apparently the jury didn't just ignore the confessions. According to the murder shits, go and watch my video this morning. According to them, the jury didn't really pay much attention to the confessions. But we've also heard that the jury didn't pay much attention to the bullet either. So they didn't make much of the bullet. They didn't make anything of the confession. So what evidence did they actually use? That Richard Allen was bridge guy, because that's all that was left. So, don't know. I found solitary confinement the most forbidding aspect of prison life. There is no end and no beginning. There is only one's mind, which can begin to play tricks. Was that a dream or did it really happen? One begins to question everything. That's a quote by Nelson Mandela. Solitary confinement is a form of punishment and, depending on its conditions, even torture. By 2023, when Alan was held in solitary for 13 months, it was well established that prolonged isolation causes psychological pain, suicide ideation, and psychosis. This is nothing new. This is not rocket science. We are not reinventing anything here. It is well known, not only in humans, but also in a bunch of non-human animals. You know, animals that live in social groups. Solitary confinement sends them crazy. We've seen it in a whole range of different animals kept in cages on their own with no stimulation and nothing to do. It sends them crazy. They bite their own paws off and fur off and God knows what. Much like what Richard Allen was doing. Okay. To prevent inmates from psychological harm, the IDOC strictly prohibits solitary confinement over 30 days for anyone with serious mental illness and requires transfer if serious mental illness symptoms appear. When Alan exhibited the predictable symptoms of psychological pain, confusion, and psychosis, IDOC administrators refused to transfer him to a mental health unit. When Alan's attorneys informed the court of his dire condition, the court also refused to move him and actually said that he was being treated better than any other prisoner in Westville. The prosecutor delayed and mocked counsel's concerns when collecting evidence of Alan's confessions. Yeah. Told them that they were liars. The question for this court is unprecedented but simple. Should the state be able to benefit from Alan's psychological pain that their deliberate indifference to his mental health caused? Human decency provides the answer. No. Standard of review and additional facts. An appellant court reviews a suppression denial for substantial evidence of probative value that supports the trial court's decision. It considers uncontradicted evidence favourable to the defendant and reviews legal issues de novo. The voluntariness of a confession is a legal issue. Absolutely. That's why you like forced confessions, holding a gun to someone's head to make them confess, beating them up to make them confess, waterboarding them to make them confess, are all outlawed. You can't do that, right? You can't do that to people legally to get them to confess. So what did they do instead? They sent him to Westville and sent him crazy. But it should be exactly the same thing. It should not be legal to have someone in that state make confessions that then are used in a court of law to convict him. No. The last time I looked, the United States was a civilized country. We're not living in some kind of lawless backwater in Indiana, are they? I hope not. Alan moved to suppress his statements made while in solitary confinement, which, of course, the court denied. The court reasoned that statements were voluntary because Alan failed to show they resulted from state psychological coercion or coercive interrogation. The court found Alan's detention was intended to protect him and that while he suffered from major depressive disorder and anxiety, he did not have serious mental illness that would render his statements involuntary. I don't know what the court feels serious mental illness looks like. I don't understand how Richard Allen's behaviour was not considered serious mental illness. The guy was catatonic at one point. Good God. In addition to IDOC records and videos like those admitted at trial, Allen proffered an order and settlement from Indiana Protection and Advocacy, IPAS, versus IDOC, that the trial court excluded from the suppression hearing as irrelevant. In 2011, the Southern District of Indiana held that IDOC's housing of serious mental illness inmates in solitary constituted cruel and unusual punishment, violating the 8th Amendment. The Southern District found SMI includes delusional disorder, psychotic disorder, and major depressive disorder, which can in itself make you psychotic. This is how this is incredibly important. This has got to win on appeal, because if it doesn't, then everybody's in danger. And I'm not saying this to be hyperbolic here. Anybody who thinks that they have constitutional rights and that they have protection under the law, if this is allowed to sit on the statute in Indiana as a successful conviction, it opens the door for this kind of thing to happen, not just in Indiana, but anywhere. Anywhere. You've got to draw the line in the sand somewhere and say, no. Whether he's innocent factually or not, no. This can never, ever happen again in any civilized society. This can never happen again. Never. And you should believe that, whether you think Richard Allen is guilty or not. Because next time it could be you or someone close to you. Segregation is harmful to prisoners with SMI due to lack of social interaction, significant sensory deprivation, and forced idleness, leading to decompensation and psychological pain. An inmate decompensating from solitary may experience hallucinations, sleep disturbance, memory problems, anxiety, paranoia, depression, eating problems, or engaging in self-injury or suicide. Well, Richard Allen had all of those, all of them, every single one. Suicide watch further exacerbates the illness. It's bizarre, isn't it? The suicide watch makes it worse. The severe conditions in the segregation units cause a predictable deterioration of SMI prisoners' mental health, and the IDOC has explicitly observed, diagnosed, and noted patient decompensation. The IDOC knew these effects occurred even in non-SMI offenders. Anybody, you could be the mentally most rigorous, mentally most resilient person that has ever walked this earth. Put them in the conditions that Richard Allen was in, and sooner or later that person is going to lose their shit. They are going to become insane, psychotic, and they're going to look like Richard Allen. Simple as that. There's only so much any human being can take. Before a hearing on relief, the parties reached a settlement including an expanded definition of SMI that subsumed the court's definition. The IDOC's policies refer to the settlement, which sets the policy's tone. An inmate with SMI can only be held in solitary for 30 days. If an inmate decompensates into SMI and is unlikely to return to general population within 30 days, transfer is required. Allen admitted Dr. Westcott's 127-page report. On August 21st, 2023, Westcott evaluated Allen, who had been in Westville for over 9 months. He was terrified, unsure what was real, and wondering if he was dead, in hell, or waiting for heaven. So that was in August, when he was over the worst of it, in August. But still, if you don't know whether you're alive or dead, there's something terribly wrong. If you do not know whether you are alive or dead, then you are not in reality. So in August, he's psychotic still. Dear God. He could not recall weeks of early 2023, including playing with feces, confessing, or banging his head. He believed he had been drugged, which he had, because they'd been giving him involuntary Haldol injections. So they were saying that he wasn't psychotic, yet they were giving him Haldol in injection form. So why were they giving him an antipsychotic medication if they didn't believe he was psychotic? Westcott cited IDOC records showing acute periods of confusion, paranoia, delusional thinking, cognitive slowing, aggression, and combativeness. During this period of loss of touch with reality, Alan confessed. Westcott concluded Alan's psychosis stemmed from major depressive disorder, his personality, and the well-known effects of solitary confinement. Alan was grossly disorganized, delusional, and paranoid. Objective testing ruled out malingering. Because you can test for that. Did the state of Indiana test for that? No. Did the prison system test for that? No. But you can test for malingering. The trial court abused its discretion by refusing to admit the I-pass order short settlement into the suppression hearing, which is insane. Insane. Evidence is relevant if it's got any tendency to make a fact of consequence in determining the action, more or less probable than it would be without it. Here, the order short settlement makes it more likely Alan's psychosis was caused by his confinement. The order found solitary confinement causes all of the symptoms Alan experienced. Alan was more likely to decompensate because he spent 7 months on suicide watch, an even more restrictive form of solitary. The order short settlement also makes it more likely Alan was subjected to psychological coercion by showing solitary causes psychological pain. It demonstrates state action, the IDOC placing and keeping Alan in solitary, knowing it was causing this predictable pain. The order short settlement shows how extensively IDOC violated its own policy, as it includes major depressive disorder in the SMI definition, restricting Alan's solitary to 30 days. Alan was harmed by the court's refusal to consider the order short settlement because it undermined the court's findings and conclusions. The state failed to prove Alan's statements made while gravely disabled were voluntary. US Constitution. The state failed to prove that Alan's statements were not a product of psychological coercion. An involuntary statement obtained through state action violates due process and is inadmissible. A confession is voluntary if it's a product of rational intellect and freely self-determined rather than overborne will by state law enforcement conduct. State law enforcement can include psychiatric facilities and prison staff. Before anybody says, oh yeah, but he wasn't having a law enforcement interrogation. No, sort of that. Statements produced through a coercive environment are involuntary, regardless of whether solicited through police interrogation. Thank you. Thank you. Thank you. Thank you. Thank you, thank you, thank you. So in this case, months spent in solitary, deprived of light, adequate food, and contact with the outside world is by itself sufficient to sustain a finding of involuntariness. Then another case, staff at a state's psychiatric facility created a coercive environment, rendering a juvenile's confession involuntary. The crucial element here is police overreaching. Well, there was everybody overreaching in this case. When state actors use more subtle forms of psychological coercion, the defendant's mental illness is more significant in the voluntariness determination. But the state must still exploit the defendant's illness with coercive tactics. Says that case? Are we talking about that case? It's generally done through aggressive interrogations, but exploitation can occur in other ways. Difficult to imagine a situation in which a confession would be less the product of a free intellect, less voluntary, than when brought about by a drug having the effect of a truth serum. Yeah, they were giving him these Haldol shots. They were fucking about with the normal medication that he took. Who knows what he was saying when he was under the influence of drugs that he may or may not have needed. He should have been in a psych ward so that they could get his medications right. For a statement to be involuntary, state action must be casually related to the confession. The state's prolonged solitary confinement of Alan was state action. Contrary to the court's finding that Alan failed to prove state psychological coercion, it was the state's burden to prove Alan's statement voluntary by a preponderance of evidence. To the extent Alan had a minimum burden of production, he met that. Prolonged maximum security solitary confinement of a pretrial detainee, especially after psychosis develops, is state action. Unlike the mentally ill defendant in Connolly, who walked into a police station and confessed, Alan never voluntarily came into custody. He consistently protested innocence until and during 5 months of maximum security solitary with no human contact except when chained or caged. And I don't think we know the half of it. I don't think we know the half of it. I mean, what were these guards saying to him? You know, these Odin guards. What were these suicide companions saying to him? We don't know what they were doing to him. We don't know if they were fucking up his food. We don't know if they were depriving him of, water. We don't know. We don't know if they were shouting and screaming all night to deprive him of sleep. There could have been all sorts of stuff going on that we've never heard about, that probably Richard Allen cannot even communicate that happened. He probably can't even communicate those things. So his attorneys probably don't know. Because it was pre-trial, Allen's solitary was unprecedented and borderline, if not constitutional punishment. Or unconstitutional, rather. Other IDOC safekeepers were in mental health units, not solitary. On a continuum of possible punishments in the justice system, solitary confinement in a maximum security facility is the most extreme. Also, Allen's solitary exceeded the 30-day IDOC policy restriction. IDOC knew it could harm Allen. Of course they did. That's what they were banking on. When IDOC observed Allen's predictable deterioration, they refused to transfer him, keeping Allen in solitary when he, no doubt, SMI was an administrative, not clinical decision. Finally, the state's conduct also involved the prosecutor, law enforcement, and the court. After Allen filed his April 5th emergency transfer motion, citing his dire condition, the prosecutor waited 9 days to respond while investigators monitored real-time calls in which Allen confessed. We don't know what they said to him to get him to confess. We don't know what they were saying to him. We don't know if they were telling him what to say. We don't know if they were bribing him. We've got no idea what they were doing to him. During this delay, Allen continued deteriorating. The prosecutor then mocked defense concerns as colourful and dramatic, while the same day, IDOC found Allen gravely disabled. The very same day that Nick McClelland was calling the attorneys dramatic and colourful and calling them liars, Richard Allen was classified as gravely disabled. Yet, the very same psychological staff also simultaneously thought he was feigning. All right. Knowing Allen was decompensating, the court refused to transfer him, putting the onus on IDOC to provide care. It is fundamentally wrong to keep a gravely disabled Allen in solitary while using against him statements made to psychologists and suicide companions. 1 week later, the prosecutor sought all medical records, videos, and communications while confessions were ongoing. Monitoring and collecting his statements consumed hundreds of hours and produced over 60 confessions. ISP interviewed inmates and guards and even sent a psychologist to speak with Dr. Waller. Allen showed more than sufficient state action. The state's prolonged pretrial solitary confinement was psychological coercion. Allen's solitary was psychological coercion because it was prolonged, caused psychological pain, and put him at the mercy of the state. The prolonged nature is coercion because solitary confinement can bring a person to the edge of madness, perhaps to madness itself. In this case, very, very, very mad. Very mad. Very mad. Dear God. It's been recognised in literature, law, and science. It's like in Dickens, A Tale of Two Cities. Okay. Angrassian psychiatric effects of solitary confinement. Solitary causes psychological trauma, including psychosis, hallucinations, and paranoia. Okay. From day one at Westville, Allen was placed in a strip cell, the most restrictive cell in the most restrictive solitary unit, the worst of the worst, with only bare essentials and a camera constantly recording him. Soon thereafter, IDOC ordered guards to videotape him when out of the cell, including showering and attorney visits. Suicide companions remained outside his door, documenting everything, regardless of suicide watch status. He had no contact with anyone unless caged or chained. In the sensory deprivation, social isolation, and forced idleness is difficult even for healthy people. A healthy man wrongfully implicated and detained in solitary questioned his memory and suspected he had committed the crime, thought he stayed sane by reading, exercising. Also, though he stayed sane by reading, exercising, and praying, the experience traumatized him. Okay, early videos show Allen pacing his 8.5 by 12.5 cell, laying down, doing leg crunches, writing, reading, and looking distressed. Okay, so all of those things maybe on the normal spectrum of stuff that you would do if you were in prison for the very first time. Cell videos, December to March. Okay, that was probably normal, or maybe worse end of normal. Within 2 weeks, Allen said he was broken and told his wife, if this becomes too much for you, call the detectives and I will tell them whatever they want to know. Had Allen's solitary been 30 or even 90 days, he would not have decompensated, but it was 13 months. The prolonged solitary caused Allen predictable psychological pain, paranoia, nightmares, memory problems, and confusion. It is undisputed Allen deteriorated to being gravely disabled and very psychotic. The words that the psychological staff used, their own words, and the IDOC involuntarily administered antipsychotics between April and late June. Although Waller noted concerns about feigning, she diagnosed psychosis and suspected incompetence and over-medication. Yeah. So she questioned whether he was competent to, progress in his case, yet at the very same time, the confessions that were used at that time were used against him at a trial. Make that one make sense. And Westville only monitored Allen's mental health. Talking with a psychologist while shackled in a cage is not treatment. It's not. It's really not. Solitary put Allen in a constant state of vulnerability. Solitary confinement has long been recognised as psychologically coercive, equal to the rack, the thumbscrew, and protracted questioning. Pre-trial solitary is punishment already underway and conveys, without the necessity of spoken words, the implied threat of further punishment. Yeah, it's meant to terrify you. It does not matter why a defendant was in solitary, whether justified or whether the prison planned further punishment. It's what's going on in your mind that's important. The prison doesn't have to do anything else. Your mind will do the rest. Put somebody in solitary, your mind will do the rest. In this harsh environment, Dr. Waller controlled all aspects of Allen's life, including whether he got bedding, clothes, meal items, books, personal items, and utensils. That's insane. Why does a psychologist have so much control over anybody? Why? That's insane. She could provide a new window and a tablet or strip him to bare necessities. Privileges were contingent on pleasing her. Whether Waller had ill intent is irrelevant. It is what Alan thought and what solitary confinement did to him or would do to many of us, to all of us eventually, no matter how strong you are. After confessing to Waller on May the 3rd, he asked for his property back and she indicated she needed more consistency. So he had his property taken away so that he would confess. And she probably said, you know, if you come clean, if you tell the truth, if you say what I told you to say, you can get your stuff back and you can get a visit from Cassie or something along those lines. And she needed more. So she said, oh, I need more consistency. I need you to say it again. I need you to say even more. She had him by the literal balls. This is sick. This is sick. Senator McCain, a prison camp survivor, explains solitary, crushes your spirit, weakens your resistance more effectively than any other form of mistreatment. Atul Gawande, hellhole, the New Yorker. Oh, so that's back in there. Okay. Alan entered solitary confinement compromised. He left broken. Yeah. I wonder how he's doing now. I mean, I dread to think. Alan's confessions were a product of solitary-induced psychosis, not rational intellect. IDOC records show that Alan continued to suffer from psychosis during the times he confessed. On April 5th, when he confessed to Dr. Waller, he was not eating or sleeping and was drinking from the toilet. On May 3rd, when he confessed, Alan had symptoms of paranoia and disorientation, despite Waller claiming he presented as more organised than he had been. The day before, he was confusing nightmares with reality and claiming to have started World War III. 2 days before, he was too disjointed to hold a conversation. Days earlier, he covered himself in feces and claimed he was King Michael, whoever King Michael is. His confessions to guards occurred during bizarre and psychotic behaviour. Guards believed he was faking, but they were not clinicians. Dr. Westcott found no malingering through objective testing. Alan confessed to his family on April 3rd, May 10th, May 17th, May 25th, and June 11th. On May 3rd, he fell on the floor, asked if he was dead, and was suicidal. On May 10th, he believed he was dead, that the world would blow up if he slept. His water was poisoned, it probably was, and he was reliving the same day. Well, wouldn't you imagine that every day is Groundhog Day if you're living like that? On May 17th, he was paranoid of attorneys and staff with hoarding patches. On May 25th, Alan paced for 2 hours and banged his head. On June 11th, he thought he was in hell and did not understand what was happening. In August, Alan did not remember confessing all the weeks in early April. Throughout, he complained of memory loss. State action overbore Alan's will. Alan did not confess until after 5 to 7 months of solitary. Before arrest, he consistently denied involvement. Dr. Westcott opined Alan's psychosis was caused by the stress of solitary confinement or pre-existing illness. Dr. Waller agreed a lot of time solitary confinement exacerbates mental illness and is reasonable to believe Alan's confinement caused this psychosis. The social isolation of solitary makes people question their self, the very essence of themselves. If you are treated like you are guilty, you believe to think you are. Dr. Gracian testified a false memory starts with a belief. In his first confession to his wife, Alan said, I think I did it. In his first confession to Dr. Waller, he was unsure if he'd had sex with the girls. Alan got facts wrong and confessed to crimes he did not commit. So he claims to have shot the girls, abused his sister and his daughter. There was a confession where he confessed to killing his grandchildren that he didn't even have. Started World War III. Well, as far as we know, that's not happened just yet, but I don't know. Maybe if Alan falls asleep, that's when it starts. Who knows? Indiana Constitution. The state failed to prove Alan's statements were a product of rational intellect rather than the state's misconduct. The Indiana Constitution also protects against the admission of involuntary statements. Indiana's test is like the due process standard, requiring a confession to be freely self-determined by a rational intellect and free will. However, it's more robust because it requires the state to prove voluntariness beyond a reasonable doubt. Also, it does not require state action to be coercive to overcome a mentally ill person's will. Mental ill defendant's statement involuntary due to resultant state and confusion, although officers neither coerced him nor knew of his illness. But mental illness alone will not render a statement involuntary. There must be some state negligence that contributed to overcoming the defendant's rational intellect. Here, the IDOC's refusal to apply their 30-day policy to Alan and to transfer him after he deteriorated is, at minimum, negligent state conduct. It's more than that. No words for it. That caused Alan's psychosis and confessions, and the prosecutor's delay and the trial court's refusal to set a timely hearing exacerbated the deterioration. This is conduct that our Constitution cannot tolerate, regardless of whether it constitutes coercion under federal due process. Also, the evidence does not show the statements were a product of rational intellect beyond a reasonable doubt. Alan was considered gravely disabled through June 16th, when he received his last emergency injection due to self-harm. Though Waller sometimes described Alan as more coherent or his symptoms not significant, the state cannot have it both ways, i.e. Alan decompensated to the point of forced medication but remained rational beyond a reasonable doubt. Doesn't make sense, does it? Even if Alan could occasionally hold a conversation, it does not render his confession voluntary. Even if the court finds Alan's statements voluntary, they are a product of unconstitutional detention. Thank you, Joanne. Thank you so much for the £20. Thank you, thank you. You are so kind. Alan's prolonged solitary confinement. Indiana courts are constitutionally bound by the basic concepts of fairness that are frequently identified with due process in the federal Constitution. Okay, article blah, blah, blah. Guarantees for every person, for every injury done to him in his person, remedy by due course is... But what? Let me read that again. Article 112 guarantees for every person, for every injury done to him in his person, remedy by due course of law. Okay, I think you get that. Here, Alan was sent to solitary for safekeeping without even a hearing or notice. Yeah, he was just sent there. He didn't even have attorneys when he was sent to Westville. There was nothing. There was no hearing, nothing. Nothing. Even when his attorneys informed the court of his dire condition, the court refused to set a hearing. Yeah. And when they did finally get a hearing in June of 2023, they got called liars and dramatic. Although the court eventually held a hearing on June 15th, 2023, by that time the damage was done and they had the confessions, so it was all fine. Fairness protections in criminal cases are found in different Indiana constitutional provisions. Just as pretrial punishment violates federal due process, it violates the Indiana Constitution. Indiana is one of just 6 states protecting citizens from unnecessary rigor. The framers wrote, in person, arrested or confined in jail shall be treated with, What? Oh, okay. No person arrested or confined in jail shall be treated with unnecessary rigor. Typically, this provision requires a prisoner suffers severe mistreatment. Recognizing this provision applies to solitary confinement, the Indiana Supreme Court states, the very essence of punishment and the sole use of the prison walls is the confinement of the convict within them. Humanity indeed forbids as unnecessary rigor that his confinement should be absolute solitary, or that all his natural and civil rights should be temporarily annihilated. Here, Allen's treatment rose to the level of unnecessary rigor. Rigor is the act or instance of strictness, severity, or cruelty. When Allen started suffering from confusion, memory lapses, paranoia, and bizarre behaviors, there was no longer a risk he could not handle the harsh conditions of maximum security solitary. It was a reality. The strictness, severity, and cruelty of his confinement is evidenced on video, where he's screaming in fear, confused about where he is, unable to respond, and drooling and self-harming. The rigor was physical too. Oh, dear God. Allen lost 40 pounds, was unable to care for himself, was tased, his face was black and blue, and at times bleeding. He was poisoned by fecal matter and toilet water. Indifference to his catatonia was shown where medical staff discussed blood pressure and cholesterol with a vacant Allen. Unbelievable. Unbelievable. This psychological and physical pain was unnecessary. IDOC could have transferred him upon deterioration as policy requires. Even an isolated infirmary cell would have been better than the hole designed for punishment. Likewise, the court could have moved him when the court learned of his dire condition. No, of course not. Of course not, because it's Gull and Nick. Little buddies. The constitutional violations require suppression. Over 150 years ago, oh God, right, Dostoevsky, maybe, wrote, the degree of civilization in a society can be judged by entering its prisons. Davis, writing about the effects of solitary, Justice Kennedy hearkened to this quote, noting, there is truth to this in our own time. Applying the exclusionary rule to these constitutional violations would deter abusers within our prison systems and law enforcement, protect judicial system integrity by showing it condemns such conduct, and protect the human dignity of those unable to make bond while awaiting trial. Absolutely. It should be scary to everybody. This can never, ever, ever happen again in any civilized society. This cannot be allowed to sit there without being thrown away, torn up and thrown away. And Richard Allen be given the end, I don't know, $1 billion or something for as restitution. Excluding confession that was a result of physical abuse and solitary, blah, blah, blah. Indiana has a robust exclusionary rule. Relying on Article 1, 11, 14, Indiana adopted the exclusionary rule long before the Fourth Amendment exclusionary rule applied to the states. Under the exclusionary rule, to determine whether a statement is a product of an illegal detention, the court must ask if the statement has been come at by exploitation of that illegally or instead by means sufficiently distinguishable to be purged of the primary taint. Interesting words. The court considers the time elapsed between the illegality and the acquisition of the evidence, the presence of intervening circumstances, and the purpose of flagrancy of the official misconduct. First, Allen's statements occurred during the illegality of his detention at Westville. Second, there was no intervening circumstances. Again, there is a well-known connection between solitary confinement and psychosis and delirium. Third, the constitutional violation was flagrant because IDOC violated its own policies for keeping Allen safe, and the court and prosecutor refused to help when Allen's attorneys warned of his deterioration. Even if this court finds Alan's statements were voluntary because he was not interrogated by law enforcement, he was still gravely disabled when he confessed. As such, his free will did not purge the taint of his illegal detention. The trial court erred by denying the motion to suppress. The error was not harmless. Before a federal or state constitutional error can be held harmless, the court must find it was harmless beyond a reasonable doubt. No piece of evidence may have greater sway over a jury than a defendant's confession. The erroneous admission of statements to Dr. Waller alone was prejudicial because they were a large part of the state's case and they made no sense, but the jury obviously couldn't put it together. The prosecutor particularly concentrated on Alan's May 3rd statement, arguing that Alan knew a fact only the killer would know. The confession also countered Alan's confident and unwavering pre-solitary protests of innocence. And it wasn't a detail that only the killer would know. It wasn't. It wasn't even a detail that only the killer would know, because loads of people knew about the van. So probably all of us are guilty. Probably all of us did it. All of us who knew about the van knew something that only the killer would know and therefore are guilty. That's basically what the state of Indiana are saying, basically. And also, I've got a quote now that's somewhat similar to Bridge Guys. I'm getting a bit concerned. I must never go to Indiana. That's the good. They're just going to nab me. They're going to nab me as soon as I get off the plane. The court denied Alan his rights to present a complete defence. Oh, so we're on to point 3 now. Waller knew about the van. Everybody did. All you had to do was snoop around the Facebook groups like she was doing, and you knew about the van. We knew about the van. I don't know when. Well, listen, I knew about the van before 2019 because I lost all interest in this case after the press conference in 2019. So I was following this case up to April of 2019 when they did the change of direction press conference. And I kind of just lost interest because I was like, they clearly have no clue. They have no idea. Everybody's just chasing the tails. I'm sick of this. And I dipped out of the case until Alan was arrested. And then I came back. I knew about Brad Webber and his van before that point. And I wasn't someone who was sitting in Delphi Facebook groups every day. I only knew, like, I'd been in Delphi Facebook, you know, I'd looked around, you know, the social media and stuff. And I knew about the van. I wouldn't have called myself a complete expert on Delphi in those days, though. And I knew about the van. So what can you do? Because loads of people, the thing is, I knew about the van because loads of people were blaming Brad Webber. That's why there was discussion about the van. And like his mother had come out talking and it was all really weird because his mother wasn't there. And all that stuff was doing the rounds in the early days of the case. Yeah, so was I. When Rick Allen was arrested, I was like, great, they got the killer. So was I. So was I for, I'd say, a good, well, till Frank's. So till September of 2023. So for 10 months, I thought that they got their guy. I thought, all right, the probable cause affidavit, it's not the strongest I've ever seen, but it's not even the weakest I've seen. And it was when Frank's came out that I was like, oh, hold on a minute. Maybe there's another side to this. Maybe there's a whole big wide world out there that I'm not paying attention to. Let's think about this. And even still, I said, I don't know if Richard Allen is factually guilty or not. I do not know. Even at that point, I said that. And then the more I looked into stuff, the more I really sat with these details. It's like, no, and no. And the more that came out, the more that the state of Indiana tried and denied and wriggled, the more certain I became that Richard Allen was innocent. And then finally, at the trial, when we got the full details, I know we didn't actually see the full details, but we got the details, fortunately, from the handful of people who were able to sit through the trial. I said, no, this makes no sense. The timeline doesn't work. The details don't work. It's all a lie. And the jury fell for it. But now we're in the situation where the jury have said that they didn't really pay much attention to the ballistics. They also didn't pay much attention to the confessions. So what's left? Because there was no DNA from Richard Allen at the scene. They found nothing on his computer or anywhere that connected him to Abby and Libby or any of the families. So what is there? What was there? Was there, well, he looks a bit like Bridge Guy, and he wore the same coat as Bridge Guy, or even the same colour coat as Bridge Guy, and he wore jeans. Is really that it? Is really that it? Is really that what decided the jury that he was guilty beyond a reasonable doubt? Really? Come on now. This is wrong. This is any shade of wrong you would like to colour. This is wrong. It's all wrong. All right, moving on. Number 3. The court denied Allen his right to present a complete defence, to explain the scene and impeach the investigation. The 14th Amendment guarantees a defendant the right to a fair trial. The amendment's due process clause places significant substantive limits on state power, prohibiting its arbitrary exertion and guaranteeing criminal defendants a fair opportunity to defend against the state's accusations. For an opportunity to be fair, a defendant must be permitted to confront and cross-examine witnesses and to call witnesses of his or her own behalf. These overarching principles operate in tandem with the 6th Amendment, which similarly guarantees criminal defendants a meaningful opportunity to present a complete defence. Although state trial courts have broad discretion in conducting trials, this discretion has constitutional limits that completely get ignored by Frankel. That is, courts may not infringe upon a weighty interest of the accused through decisions that are arbitrary or disproportionate to the purposes they are designed to serve. As explained more fully below, the trial court made several reversible errors under the rules of evidence and Indiana's trial rules. In many instances, these decisions violated the Constitution as well. Standard of review. While this court assesses claims relating to admitting or excluding evidence for abuse of discretion, to the extent those claims implicate constitutional issues, this court reviews them de novo. Errors in the admission of evidence will be disregarded as harmless if its probable impact on the jury, in light of all of the evidence in the case, is sufficiently minor so as not to affect the substantial rights of the parties. But when the error is constitutional, this standard is higher. Generally, before a federal constitutional error can be held harmless, the court must be able to declare a belief that it was harmless beyond a reasonable doubt. The court committed reversible error by excluding Blair's sketch of Bridge Guy. At the trial, the court prohibited Allen from using Blair's sketch of Bridge Guy. This decision violated all rules of evidence and denied Allen his constitutional right to present a defence of mistaken identity. Evidence is relevant when it has any tendency to make the existence of any fact that is of consequence to the determination or action more probable or less probable than it would be without the evidence. A court may exclude relevant evidence if its probative value is substantially outweighed by a danger of unfair prejudice, confusing the issues, misleading the jury, undue delay, or needlessly presenting cumulative evidence. Blair's sketch proves she did not see Allen on the bridge. Blair did not identify Alan in court. Nobody did. Nobody did. Nobody was asked to, which is shocking in itself. But accordingly to the prosecutor, Blair must have seen, so according to the prosecutor, Blair must have seen Alan on the bridge because Alan told us he went on the Monon High Bridge out onto the first platform, which is exactly where Blair saw Bridge Guy. Blair's sketch shows Alan looks nothing like the person Blair saw. Just 3 days after the murders, Blair met with the sketch artist and described the man she saw on the bridge as white, about 20, of medium build and having brown curly hair. An artist created the following sketch based on Blair's description. Now, those jurors who disregarded the bullet, who disregarded the confessions, all they had left was the eyewitnesses of Bridge Guy. This sketch, had this sketch been shown to the jury, would that have been enough to render a not guilty verdict? Because there wasn't anything else. The guilty verdict came from how the prosecution linked Richard Allen to being Bridge Guy. So show them that sketch and just ask them to compare that sketch with Richard Allen. So there's a jolly good reason why Nick McClelland did not want the jury to see that sketch. This looks nothing like Alan. At the time of the murders, Alan was short, 44 years old, with closely cropped hair. Blair's sketch also shows that she and Carbo saw different people. The state's timeline for the murders is dependent upon Carbo and Blair seeing the same person. And the prosecutor told the jury that every eyewitness is adamant that the person they saw was Bridge Guy. There is no doubt in their minds. But Blair's sketch disproves this claim. Carbo, like Blair, made a sketch. When Blair saw it, she described it as wrong and not who she saw. Blair's sketch impeaches the investigation and shows law enforcement bias against Allen. For 2 years, law enforcement circulated Carbo's sketch without it yielding a single arrest. So in April 2019, which is when I lost interest in this case, ISB released Blair's sketch, declaring it represented the face of Bridge Guy, and it announced that Blair and Carbo did not see the same person. After Allen's arrest, the story changed, and the jury was told Carbo and Blair saw the same person. You know, you remember what Doug what's his face said? You know, if you put the two sketches together, then you get Bridge Guy, and that person is Richard Allen. Whatever, Doug Carter. Yeah, okay. Blair's sketch was reliable and probative of Bridge Guy's identity. Probative. Is it probative or probative? Probative, isn't it? Probative of Bridge Guy's identity. Blair contacted law enforcement the day the girls went missing. And it was very clear to her she saw Bridge Guy. 2 days later, she developed her sketch with an artist and a book of facial features. She rated her sketch 10 out of 10 for accuracy. In 2019, she met with law enforcement repeatedly, and she reaffirmed her confidence in her sketch. She insisted she could identify Bridge Guy if she saw him. Well, if I was Betsy Blair, I would have said, that's not who I saw. I would have said that. I would probably have been held in contempt, knowing Francis Gore, but I would have said, he is not who I saw. I'm sorry, he is not who I saw. Blair's sketch is not hearsay. Indiana bars the use of out-of-court statements for the truth of the matter, asserted until the statement falls within an exception. Here, Blair's sketch was not a statement. Although Indiana has not reached the issue, other courts hold that a sketch is a functional equivalent of a photograph. No statement is involved. The sketch is not hearsay. A statement is not hearsay if the declarant testifies and is subject to cross-examination about a prior statement, and the statement is an identification of a person shortly after perceiving the person. What? The rule applies regardless of whether the identifying witness makes a positive in-court identification or not. Here, Blair identified Bridge Guy to law enforcement immediately and developed her sketch 3 days later. Blair's sketch is also admissible as an adoptive admission. A statement is not hearsay when it's offered against an opposing party or is one the party manifested that it adopted or believed to be true. Some confusing sentences here that occurred here. In April 2019, the ISP released Blair's sketch to the public and declared this is the face of Bridge Guy. Blair's sketch is admissible under Indiana's common law too. Decades before Indiana adopted the rules of evidence, sketches were admissible if the eyewitness took to the stand at trial. Yeah, loads of trials have the person like on the stand shown a sketch. Like, is this the sketch that you did? Or is this the sketch that you helped with? Is this your sketch? Loads of them. Even if the sketch was an inadmissible hearsay, Allen was still entitled to use it. State law does not have the last word on hearsay. And the rule must yield to the constitutional right to present a defence. Blah, blah, blah. Hearsay, hearsay is admissible when other law requires it. When identity is crucial to the case. A defendant is entitled to defend on a claim of mistaken identity, and this right cannot be abridged through the application of arbitrary or disproportionate rules or the mechanistic application of otherwise rational rules. Excluding the sketch violates the Constitution. Here the state concedes that Bridge Guy's identity was crucial to the case. It was the case. It was the case. That was the case. If we can determine who Bridge Guy is, we can determine who killed Abby and Libby. Yeah, that's what Nick McClellan said. Blair's sketch was critical to Allen's defence of mistaken identity, and the judge's decision to exclude it was arbitrary and disproportionate to any legitimate government interest. The error was harmful under both constitutional harmless error standard and Indiana's evidentiary standard. There is no dispute the state's timeline depended upon 1, Blair seeing Allen on the bridge, and 2, Blair and Carbo seeing the same person. Blair's sketch disproves both points. Excluding it affects Allen's substantial rights and the jury's verdict. I think it would. I think if the jury were really that narrow-minded, then that sketch could have been the difference. That sketch could have been the difference between where we are now and Richard Allen being at home for Christmas. Last Christmas, as well as this Christmas. The court committed reversible error in excluding Tobin's testimony. Allen tendered William Tobin to explain the scientific community's robust criticism of the AFDI's tool mark matching methodology. So this is relating to the bullet. The judge excluded him because he was not a firearms expert. He was untrained in firearms identification. He did not examine the evidence in this case and did not conduct a firearms examination. According to the court, Tobin's testimony does not go to an issue before the jury and lacks relevance. This decision violated all rules of evidence and violated Allen's constitutional right to present a defence. Expert testimony should be admitted if 1, the expert is qualified by knowledge, skill, experience, training or education, and 2, the testimony will help the trier of fact to understand the evidence or to determine a fact in issue. Indiana adopted this rule to liberalise the admission of expert opinion. Tobin was clearly qualified to explain the scientific community's robust criticism of the AFDI methodology. Tobin was a nationally recognised expert in forensic metallurgy. I don't think anybody can say that. And material science, who has testified as an expert in many cases involving the validity and reliability of firearms and tool marks. He has extensive experience in metallurgy, bullet and lead analysis, and tool mark principles, along with a background in statistics. He understands the President's Council of Advisors on Science and Technology, which has issued a detailed report criticising the AFDI methodology. Tobin's testimony was essential for assessing Oberg's credibility and determining what to believe. Once an expert takes a stand, their credibility is fair game for impeachment. Of course it is. And a party is free to challenge the expert's methodology with opposing testimony from another qualified expert. Yeah. Just because he wasn't a firearms expert is irrelevant. He's a metal expert. So talking about the methodology that is used in firearms testing, well, that's in his wheelhouse. That's not a reach at all. Because any bullet or weapon that's made of metal, he can opine on it from an expert standpoint because he understands metal. Dear God. Dear God. Okay. A jury is ultimately responsible for assessing witness credibility and determining what to believe. Yeah, they're the triers of fact. Here, Oberg testified that she matched tool marks on the test firings from Allen's gun with tool marks on the unspent cartridge found at the murder scene. Oberg told the jury she found agreement between the tool marks by using the AFTI methodology. She gave an error rate of 2.2% for false positives and 2.87% for false negatives. She discussed studies and articles that she reviewed to apply the methodology. And over relevancy objections, she described studies related to guns that were not even 6-hour models. A lay juror might find this testimony impressive and coherent, but AFTI's methodology is anything but straightforward. Tobin's experience would help a jury understand the scientific community's criticism of AFTI's subjective methodology and force Oberg to engage with that critique. Even if our rules tolerated Tobin's exclusion, the decision was patently unconstitutional. A defendant is entitled to a meaningful opportunity to present a complete defense. This entitles him to impeach a witness who provides a crucial link in the proof of the defendant's guilt. Although trial courts possess broad discretion to limit impeachment, the discretion cannot be used to arbitrarily exclude competent, reliable evidence bearing on witness credibility when such evidence is central to the defendant's claim of innocence. Absolutely. Totally. But then again, if the jury didn't rely on the ballistics evidence, well, what did they rely on? What did they have? Bridge guy. Here, Oberg's credibility was central to the case, and the judges arbitrarily excluded Tobin. Tobin is an expert in the AFTI methodology and its shortcomings. He is experienced with firearms identification and he examined Oberg's materials. There was no legitimate state interest in excluding Tobin. Allen did not waive his right to appeal the Tobin issue by calling Warren. What? Oh, okay. So because he called Warren, it doesn't waive his right to have Tobin as well. A party aggrieved by an erroneous evidentiary ruling is entitled to respond to the improper ruling without sacrificing the right to appellant recourse. Once the court excluded Tobin, Allen responded by calling Warren, who endorsed the use of the AFTI methodology and engaged Oberg in a battle of experts over how to properly apply the methodology to the evidence. This decision did not waive Allen's rights to appeal Tobin's exclusion. The error was harmful under both constitutional standard and evidentiary standard. The state told the jury Oberg would never been wrong. And that Allen had no explanation of how his bullet from his gun ended up between the bodies of Abby and Libby, 6 inches from Libby's foot. Had the jury heard Tobin's robust impeachment of Oberg's methodology, the outcomes in this case probably be different. I think that's probably less important than the sketch. I think the sketch, if they'd showed them that sketch, I don't think we'd be sitting here now. I really don't. The court committed reversible error by admitting hearsay to rehabilitate the timeline upon which the state built its entire case. Oh, that timeline. That timeline will be the death of me. Honestly, that timeline does not work. And it's not just the van, it's everything. The phone does not work with the timeline, with the theory that states case. Oh, no. Don't get me going on the timeline. Good God. The state built its entire case upon the following timeline. Alan encountered the girls at 2:13. He completed the murders alone, left Libby's phone at the murder scene, was spotted by Corbo leaving the scene at 3:56 p.m. and never returned. If Alan committed the murders, there should be no human-initiated activity on Libby's phone after 3:56 p.m., but there was. At trial, Alan called Eldridge, a former FBI forensic examiner, who examined the data from Libby's phone and testified that wireless headphones or an aux cable were plugged into the phone at 5:45 p.m. on February 13th and then removed at 10:32 p.m. This action would silence the phone call, and she noted that the data showed an incoming call moments before the headphones were inserted, suggesting someone was intentionally silencing Libby's phone. Since the state claimed Alan left the murder scene at 3:56 p.m., Eldridge's evidence eviscerated the state's timeline and showed someone else committed the murders. The state responded by asking Cecil, its phone expert, whether water damage could simulate headphones being plugged into LG's phone. Over a hearsay objection, Cecil testified that he Googled it. I just love this guy. Honest to God. I Googled it. He found some like Apple Health forum or something of people. It's probably the same forum that I Googled when my iPhone 6 was telling me that I had headphones plugged in when I didn't. And it helped me because it was fluff. I had to get a little pin and I picked out this fluff. But water damage is different. I'm telling you now, water damage is different because there is a sensor that changes colour that can be seen on the iPhone when it's got water damage. Did they check that sensor? No, they didn't. So we could have had the water damage answer done for us. But the thing is, right, mine was a piece of fluff. That piece of fluff was stuck in there. It wasn't like it was going to fall out by itself. So I had to fiddle about with a pin to get the piece of fluff out. So why did this phone suddenly stop registering that headphones were plugged in? Like, nobody's explained that. Like, if there was something stuck in there, you know, like, I don't know, a piece of like wood shard or something, or a bit of a leaf, which is possible because it was on the ground in the woods. Well, how come it like freed itself of that at 10:32? It doesn't make sense. Okay, so Googled it and found some unspecified, non-peer-reviewed troubleshooting forums. It's people chatting to each other on like Apple Health forums. Cecil's testimony was inadmissible totem pole hearsay. Unless our evidence rules provide otherwise, out-of-court statements are not admissible for their truth. For totem pole hearsay to be admissible, each part of the combined statement must conform with an exception to the rule. Here, the posts on the troubleshooting forum are at least double hearsay. 1, the internet forum, and 2, the statements posted there. It could be any random person writing on the internet. Oh, Cecil got the answer on a Google forum. Cecil's status as an expert does not affect the hearsay analysis. Statements contained in a reliable authority can be admitted over a hearsay objection when used to contradict an expert who is testifying on the witness stand. But here, the online forum was neither reliable nor used to contradict Cecil. No, it was used to support him, to support himself. Rule 703 does not avail the state either. Under 703, experts may testify to opinions based on inadmissible evidence if the evidence is of the type reasonably relied upon by experts in the field. The rule, however, does not authorise experts to parrot facts that the experts have nothing to. Yeah, unless he's writing on the forum, it's his comment from a forum. No. Cecil added nothing here. He was a mouthpiece for total pole hearsay that he Googled. The error was constitutional. The defendant is entitled to a fair opportunity to defend against the state's accusations. This includes the right to impeach a witness through cross-examination when they provide a crucial link to the defendant's guilt. Here, the judge arbitrarily allowed the state to undermine Eldridge's testimony with a person's internet post, and it was impossible for Allen to impeach the person through cross-examination. The error was harmful. Eldridge's testimony undermined the timeline upon which the state built its entire case. Allowing the state to rehabilitate the timeline affected Allen's substantial rights and jury's decision. Dear God. The court committed reversible error by excluding evidence that impeached the credibility of Allen's confessions. At trial, Allen sought to impeach the credibility of his confessions. The judge made 3 reversible errors. Together, the decision violated his constitutional right to present a defense. When a defendant confesses, the manner in which the confession was obtained is relevant to the confession's credibility. The court erred by excluding the audio from Allen's solitary confinement videos. At trial, Allen moved to introduce 15 videos showing the conditions he endured in solitary confinement. The court sustained the state's hearsay objection and ordered Allen to mute the videos when he showed them to the jury. Okay. This was a reversible error. The audio shows a delusional, confused, and disorganized mind. The evidence can only be fully appreciated by listening to it. Accordingly, Allen respectfully requests this court watch the videos with audio, especially 172, 1002, 1007, 10,152. Jesus Christ. 1201. Jeez. How many videos are there? We're into like the 10,000th video. The statements in those videos are not hearsay. Statements are not hearsay when used to prove a defendant's state of mind. This was precisely Allen's purpose in offering the evidence, and the trial court conceded this. To the extent there are older cases suggesting that a defendant could never admit his own statements, those decisions are inconsistent and should not survive the adoption of modern rules of evidence. The audio in the video is also relevant because it impeaches Dr. Waller's testimony and undermines her medical records. Waller's evidence gave the misleading impression that Allen provided organized and detailed confessions with a beginning, middle, and an end. But the omitted audio rebuts this, showing a disorganized, nonsensical, and confused Allen. On May 3rd, for example, Dr. Waller describes Allen's mind as more organized than he'd been. But the April 28th video puts this statement in context, showing a disjointed, tangential, nonsensical, and rambling Allen. He is plainly psychotic and incredible. The audio also presents a vivid picture of solitary confinement's harsh conditions. Staff talk casually to Allen. Guards remark how long feces is on his back. Oh, dear God. Inmates tell him to kill himself, and medical staff ignore obvious signs of SMI and over-medication. In one video, medical personnel ask Allen about his cholesterol and blood pressure while ignoring his catatonia and drool. Without the audio, this video presents a misleading impression that the medical professionals are attentive when in fact they are not. The error was harmful. The audio shows that Allen's statements in solitary confinement are unworthy of belief. Excluding them, therefore, affected his substantial rights and likely influenced the jury's decision. It's just inhumane. Oh, terrible. Terrible. The trial court committed reversible error by prohibiting the jury from hearing 2 phone calls Allen made on April 3rd. On April 2nd, Allen called his mother and discussed finding religion. In the early morning hours of April 3rd, Allen made 3 intertwined calls. Over objection, the jury heard the second call where Allen confessed to his wife. but the judge prohibited the jury from hearing the calls that bookended it, where Allen questioned his sanity and the veracity of his own statements. Trooper Harshman's testimony made the error worse. Over objection, Harshman claimed that when confessing, Allen was consistently calm, subdued, and solemn in tone, showing no indication of duress or stress. But the excluded April 3rd call discredits his testimony. Allen was confused and forgetful in those. He believed he was losing his mind and that IDOC was poisoning him. He referred to being mentally tortured, comparing his environment to Guantanamo Bay. Independently, this error was harmful and warrants reversal. In closing, the prosecutor told the jury Allen started confessing on April 3rd because he'd given himself to Jesus the day before. The excluded April 3 calls tell a different story. Allen was losing his mind, showing lapses in memory and confusing dreams with reality. The prosecutor got to offer an inculpatory story for how confession started, while Allen was prohibited from presenting an exculpatory story through contemporaneous evidence. I can't say that word. Evidence. The trial court erred by excluding the statements and behaviours that provided the foundation for Dr. Gracian's opinion that Allen's confessions were not credible. At trial, Dr. Gracian testified that Allen suffered from delirium, but the judge prohibited Dr. Gracian from discussing the statements that provided the foundation for this opinion, including Allen's statements that were patently false. Of course she did. This is reversible error. First, Allen's false statements were not hearsay. He offered the statements to show his state of mind and prove that he was saying things unworthy of belief. Second, even if hearsay, the statements were admissible under Evidence Rule 703, which provides experts may testify to opinions based on inadmissible evidence, provided that it's a type reasonably relied upon by experts in the field. And third, the statements were admissible because the state opened the door 3 times. Trooper Harshman testified that Allen's confessions were consistent with the facts and included details only the killer would know. The state also paraded witnesses before the jury who opined that Allen's mind was intact when he confessed and that he was faking his symptoms. And Dr. Waller testified that she had no reason to screen Allen for delirium. Allen was entitled to counter all this with evidence that his statements were false, inconsistent and with the murder scene and consistent with delirium. Independently, this error was harmful and warrants reversal. In closing, the prosecutor moulded a story that despite Allen's undisputed psychosis, his confessions were truthful. The judge affected the jury's decision when she prohibited Allen from showing that he had made repeated untruthful confessions. Together, the above 3 errors violated the Constitution. The Constitution prohibits a court from stripping the defendant of the power to describe to the jury the circumstances that prompted his confession. It's precisely what occurred here. Allen repeatedly presented evidence that placed his confession into context and impeached their credibility, but the judge arbitrarily excluded the evidence and disproportionately ruled in the state's favour. It wasn't arbitrary, was it? It was purposeful. It was very, very, purposefully directed. The trial court committed reversible error by denying Allen's motion to correct errors. Allen timely filed a motion to correct errors, arguing the state elicited false testimony and allowed it to go uncorrected. The trial court denied the motion. The 14th Amendment is violated when the prosecution knowingly solicits false testimony or knowingly allows it to go uncorrected. According to Dr. Waller, Allen confessed that he was attempting to rape the girls, but abandoned his effort and fled with them across the creek when he saw a van. At trial, the state elicited testimony from Brad Weber, who told the jury he left work at the Subaru factory in Lafayette at 2:02 on February 13th and drove his white cargo van directly home. The prosecutor told the jury that the timeline for Weber's testimony, Allen's confession, and the step data on Libby's phone matched perfectly. No, they don't. Even before this information, no, they don't. No, they don't. They absolutely don't. Absolutely don't. And proved Alan's guilt. If you take a look at the health app data, there's a pause in the movements for 7 minutes. He had 7 minutes with them. But before he can finish his deed or his deeds, he sees a van. Brad Webber is coming home from work down his private drive to his home, and he scares Richard Allen. Then Richard Allen forces the girls across the creek to a spot in the woods, secluded spot, then kills them and cuts their neck. Yeah, but the phone data does not correspond with them going over to the creek after the 7 minutes. You got to go and watch my videos on the timeline. Oh, I went to pains with all those videos. Dear me. Webber's testimony was false, and the state knew it. Specifically, security camera footage from Webber's neighbour showed him arriving home at 2:44. An FBI report shows Webber's cell phone arriving home around 2:50. The error was constitutional and requires reversal. An error requires reversal if it could have contributed to a verdict. Here, the false evidence, if corrected, would show that Webber's arrival home was inconsistent with the state's murder timeline. He arrived home 25 minutes after the pause in movements on Libby's phone, and nearly 15 minutes after Libby's phone was on the other side of the creek and hundreds of yards away from Webber's home. Thus, Webber's statements to Waller are inconsistent with the truth and suggest he was delirious. The error requires reversal. The trial court committed reversible error when it excluded Allen's evidence explaining this murder as a ritualistic killing. The trial court prohibited Allen from explaining the murder scene as a ritual killing. This is reversible error. Evidence which tends to show that someone else committed the crime logically makes it less probable that the defendant committed the crime and thus meets the definition of relevance in Rule 401. Here, Allen tendered Dawn Perlmutter, a recognized expert in ritualistic killings and atypical homicides, to explain the elements of ritualistic killing. Ritual killing commonly occur outdoors in wooded areas and near bodies of water. They occur on holidays significant to the group and commonly often involve the use of ceremonial knives. There will be symbolism at the scene. With Norse pagan rituals, the symbolism will likely involve runes, arranging natural objects in a specific way, and perhaps combining the runes with blooding the runes. You don't get bullet wounds with ritual murders. Rather, there is usually throat slitting, blood loss, and perhaps torture. You would expect the sacrifice to be displayed or arranged at the scene in a manner that is significant to the group. And finally, you will expect to see an atypical or symbolic blood pattern at a ritualistic killing. According to Perlmutter, this murder scene included all of those elements. The murders occurred outdoors in a clearing and near a large creek. The murders coincided with the Nordic holiday Valisblot, which honors Odin's son Vali. The girls' throats were cut with a knife and they bled extensively. Perlmutter found the sticks to be obvious symbolism and difficult to explain in any other way. In her opinion, the stick arrangements on Abbey mirrored the Norse rune Gibo, and the stick formation on Libby looked like a Nordic bind rune. Perlmutter also explained that the bodies were arranged in a manner consistent with a pagan ritual. The upside-down hanging body is an important element of Norse paganism because Odin hung from a tree for 9 days before discovering runes, and Odin's leg is often displayed with one leg bent behind the other. Here, the blood patterns on the girls' faces suggested a person lifted their bodies and articulated their torsos and necks above their chins. Abby's leg was bent behind the other, mirroring the classic image of Odin, and the blood pattern on the tree appeared to look like a Norse pagan Feyu rune. Perlmutter had the knowledge, skill, and experience to offer this testimony. Expert testimony should be admitted if 1, the expert is qualified by knowledge, skill, experience, training, or education, and 2, the testimony will help the trier of fact, i.e. the jury, understand the evidence or to determine a fact in issue. Here, Perlmutter is an expert in ritualistic killings and a recognized federal subject matter expert on atypical homicide and ritualistic crime investigations. And she's the author of Ritualistic Crime Scene Investigation, a field guide for law enforcement officers investigating ritually motivated crimes. She teaches about ideological and ritualistic killings, and she is familiar with the practice of Norse paganism or Odinism. She was qualified to offer her testimony. Perlmutter's testimony was not conjecture. There was always a discussion amongst law enforcement that this was a ritualistic murder and that sticks were Nordic runes. The Behavioral Analysis Unit declined to exclude pagan ritual as a plausible explanation for the murder scene. So this is the FBI. So for the person who replied to my video this morning saying, oh, the state of Indiana believes he's guilty and the judicial system believes he's guilty and the FBI believes he's guilty, and therefore what do I know? Yeah, well, the FBI thought that this crime scene was one of ritualistic killing. So unless you can prove that Richard Allen was an Odinist, I've got a problem with your comment. And whatever the state of Indiana thought, well, they're just fucking crazy anyway. I don't believe anything they say. Good Lord. Good Lord. They don't know their own laws. Never mind anything else. Or at least they pick and choose when they want to implement their laws. A consulting professor found it quite plausible the stick markings constitute an instruction inspired by Norse runes or modern recreation thereof. And an undercover law enforcement officer familiar with runes also found pagan symbolism at the scene. Perlmutter's testimony would have been helpful to the jury. Although motive is not an element of murder, juries want an explanation for the crime. And when motive is unclear or inconsistent with the defendant's guilt, juries are more likely to acquit. Similarly, when a murder scene is complex or unusual, it's important the jury receive an explanation. Here, the murder scene was complex and unusual, and the jury would naturally want an explanation. The sticks immediately stand out to any rational person as unusual and warranting an explanation. Perlmutter's testimony provides an answer, explains the scene, and offers a motive. Her testimony would be helpful to the jury. Yeah, ISP kicked FBI off the case. They did. I wonder why. Maybe they were getting too close, eh? Maybe they were getting too close. Excluding Perlmutter violated the Constitution. A defendant is entitled to answer the prosecution's case with his version of the facts, so the jury may decide where the truth lies. And a judge cannot infringe upon this right through the arbitrary, disproportionate, or mechanistic application of the rules of evidence. Accordingly, if the state offers an inculpatory explanation for the evidence, trial courts cannot use the rules of evidence to prohibit the defendant from offering an exculpatory explanation. By excluding Perlmutter's testimony, the trial court allowed the state to offer an inculpatory explanation for the murder scene while denying Allen his constitutional rights to offer an exculpatory explanation. This arbitrarily and disproportionately denied Allen his constitutional rights. Exactly, of course they did. This error was not harmless. The state told the jury repeatedly this case was about a brutal murder, and it explained the evidence in a manner that incriminated Allen. The jury received a one-sided explanation for the crime without Allen being able to counter it. The error affected Allen's substantial rights and altered the jury's decision. Nearly there. The trial court denied Allen his rights to show the state's investigation was incomplete, overlooked plausible leads, and mishandled evidence related to third-party guilt. The trial court prohibited Allen from presenting any evidence regarding the manner, quality, or thoroughness of the investigation into this murder as a ritualistic killing. The defendant is entitled to have his case proved beyond a reasonable doubt, and the accused can create doubt by showing that the investigation was incomplete, overlooked plausible leads, or that law enforcement mishandled evidence related to the third party's guilt. Here, Allen presented evidence that the state performed an incomplete investigation, mishandled and destroyed evidence, overlooked plausible third-party leads connecting to pagan rituals. After examining the scene, several officers believed it was too complex for just one person to be involved. The Carroll County Sheriff immediately thought the sticks related to pagan rituals. The day the girl went, so that wasn't Liggett at the time. That would have been Tobe Leesenby was sheriff at the time. There the girls went missing. Law enforcement learned that Abby was having a secret relationship with Logan Holder, the son of Brad Holder. That week, law enforcement interviewed Holder and his friend Patrick Westfall. Holder reported being involved in a pagan tribe and spending every weekend in Delphi, engaging in pagan rituals with Westfall and 5 or 6 others, including women. These rituals involved animal sacrifice and human bloodletting. Holder told police he owned a .40 caliber gun, but officers did not examine or collect the weapon, nor did they search his phone. Holder told police he was at work in Liberty Landfill in Logansport when the girls went missing. Law enforcement recorded over Holder's interview, permanently deleting it. In his interview, Westfall told law enforcement he knew the woods where the girls were murdered very well. He lived in Delphi at the time. He reported knowing the girls but denied ever meeting them. He also reported being a religious leader for local pagans, and he wore a necklace to the interview representing his efforts to pledge the Vinlanders, a pagan social club. Law enforcement neglected to record Westfall's interview, and when asked for an alibi, Westfall claimed he was home with his minor son. In the 5.5 years between Westfall's interview and Allen's arrest, law enforcement took no further action. After Holder's interview, tipsters repeatedly called and reported him as a person of interest, claiming he posted pictures of half-dead women with symbols off tree branches. On April 13, 2017, officers visited the landfill to investigate and spoke with an employer, Susan Case, who provided a printout showing Holder swiped out of work at 2:45. This is shocking. I didn't know this. This is absolutely shocking. Which was 30 minutes after the Bridge Guy video. Case invited the officers to review the video to confirm the printout's accuracy, but they declined, nor did they interview other employees. Unified Command marked Holder as a cleared suspect. Get this. Do they have the bit that they talk about the time card that we talked about yesterday? So the shift that Brad was on actually finished at 1:30. So actually he would have left at 1:30. So all he had to do was get someone to clock him out, like with a complete bullshit lie. Like, oh, I think I forgot to clock out. Can you just clock out for me? That's what I think happened. Okay, April 12, 2017, shortly before taking medical leave, Trooper Winters received a call from a tipster, Ryan Boucher, who shared pictures from Holder's social media. Winters found a concerning similarity between the murders and pictures posted on Holder's social media. Those pictures depicted young girls believed to be deceased with sticks placed over their bodies. Winters also noticed similarities between the sticks formation on Abby and the bind rune Holder tattooed or drew on his hand. It's exactly the same. Holder said that bind rune on my hand, basically, I took a Gibo rune and an Isa rune and I made a bind rune. Okay, cool. Holder's social media also features him holding guns and homemade knives. Winters immediately recommended to his superiors that law enforcement investigate Holder further, which they declined to do, claiming his alibi was cleared by the FBI. In 2018, Holder displayed a painting he made of Odin upside down with his right leg, and it was almost to the day. In 2018, when he posted this picture of the upside down Odin, it was almost to the day of the murders, like a year to the day, almost. Displayed a painting he made of Odin upside down with his right leg tucked behind his left, just like Abby's legs. Holder's painting also featured a red Fey rune. Winters was not satisfied and urged the ISP to conduct an investigation. No further action was taken. In September 2022, the state charged Allen. At Allen's insistence, law enforcement re-examined Holder. Holder's story about Abby began to change. In 2017, he told law enforcement he never actually met Abby. In August of 23rd, in August of, I'm going delirious here. August 2023, he told law enforcement he met Abby once. During a deposition in 2024, he said he met Abby twice. He probably met her like 3 times by now, because it's now 2025. So he's adding a meeting on every year. So it'd be 3 by now. At least one of those occasions occurred shortly before Abby's murder at Westfall's house. So Patrick Westfall also knew Abby. Patrick Westfall admitted to knowing Abby's mother. Admitted it in his own words. On April 4th, 2024, Allen's counsel deposed Case, the Liberty landfill. Oh, yeah, here it is. HR officer, and found that Holder did not have exclusive control of his employee badge on the day the girls went missing. This was mega news to me last night, this. Allen also uncovered evidence that impeached the course of the investigation even further. I think well, they're not including it, but anyway, he logged out. He should have logged out at 1:30. Like he should have left at 1:30. Uncovered evidence that impeached the course of the investigation even further. In 2018, Holder told his wife they had a fight with Westfall because Westfall wanted to up from animal slaughter to a different type of sacrifice. Holder then told her that Westfall killed Abby with others, and she needed to keep her mouth shut about it. The evidence shows a shoddy, incomplete, and mishandled investigation into this murder as a ritual killing and raises a reasonable doubt that Holder and Westfall were responsible for the murders. Allen is entitled to present this evidence to the jury, and the judge committed reversible error by excluding it. The error violated the Constitution and affected the jury's decision. The Constitution entitled the defendant to attack not only the probative value of crucial physical evidence and the circumstances in which it was found, but the thoroughness and even the good faith of the investigation as well. Here, the omitted evidence created reasonable doubt and raised questions of the utmost importance about the manner, quality, and thoroughness of the investigation that led to Allen's arrest 5.5 years after the murders, and had the jury heard it, a different result was likely. Conclusion. The very premise of our adversary system of criminal justice is that partisan advocacy on both sides of the case will best promote the ultimate objective that the guilty be convicted and the innocent go free. Not in Judge Gull's court, they don't. Because the trial court prohibited the jury from hearing Allen's side of the story, showing how law enforcement went down the wrong path, justice could not be done. The appellant, Richard Allen, requests this court reverse his convictions. Woof. Woof. Well done. Well done, my guys there. Mark, Stacey, well done. Well done. Yeah, they've not got Elvis in. Well, they're limited. They've only got 24,000 words. And Elvis, I would imagine Elvis would take a lot of words, because you've got to, Elvis's confession is really, really important. But you've then got to waste a lot of words on linking Elvis to Brad Holder. And, you know, Elvis lives over 100 miles away. He clearly does know Brad Holder, but it's quite tenuous. So I think this is the strongest information they've got. It's very concise. We know stuff that's not in here, but I think this is plenty for the appellant justices to really chew on. If this does not lead to a reversal of some kind, I literally want to leave this planet. I'll be appealing to Elon to get me onto the spaceship for the first Mars mission, because I do not want to be here anymore. I don't want to be dead, So the only thing I can do is literally leave the planet, because this planet is done. This planet is done. It's done. It's done. Right? I want to be on that mission to Mars. It's done. If this does not lead to something, now they're appealing for a reversal of his convictions. I think he should be exonerated. I don't think there was evidence ever that was sufficient to bring to bear. But if they don't go that far, then I want a new trial. And rather than him sitting there in prison, I think he should be out on parole or probation, whatever the one is, whilst he awaits a new trial. He needs to just be let go. He needs to be let go, and he needs to be let go now. He needs to be home for Christmas. And if these appeals court judges find ways to wriggle out of it, I'm sorry, you guys, if you live in Indiana, your state is lost. Your state is now lawless. Your state is just lawless. So I don't know what you need to do. I don't know whether you need to leave. I don't know what you need to do, but your state is lawless. If this does not, if this is not a problem for the justice system in Indiana, then Indiana has a bigger problem than I ever thought. So that's where we're at. That's where I'm at. Anyway, I've lost my voice almost. So I'm going to go now. So that's the document done and dusted. That's the verification of word count. So no more than 24,000 words. Has anybody actually done the word count? I can't do it on this version. It won't tell me the word count. Don't think it will anyway. Maybe there's a way. Maybe I could copy it all into Word and then do it. But no, I'm not going to do that. I'm not going to do that. I'll believe them that it's under 24,000 words. But yeah, it's a good one. It's really well written. It's, as far as I know, I don't know the law of Indiana. I'm not a lawyer, but it's very good. It's very good. All right. So well done, Stacey. Well done, Mark. You are champions in my book. You are champions. Okay, so thank you all for joining me. Thanks as always to the mods. Thank you once again to Joanne for gifting £20. And I'll be back tomorrow with a video on this channel and episode 20 of Cold Case Christmas over on Michelle Walks. What will the case be? I've got no idea. I can't remember what order I put all the cases in. So it'll be a surprise to me as it is to you. All right. So until tomorrow, I'm out of here. Bye, guys.